In this video, we will discuss the question of what makes a contract legally binding. If you're new, I'm Malcolm Zoppi, an English qualified solicitor and the managing director of Gaffney Zoppi, my law firm. And on YouTube, my goal is to make business law easy. What is the legal definition of an offer? What happens if someone makes an offer as a joke? And are advertisements recognized under the law as offers? An offer is when someone presents something for acceptance and they have the intention of being legally bound. The intention of being legally bound is especially important because that differentiates between jokes and legally binding offers. The intention of being legally bound is an objective test, not a subjective test. The difference is that an objective test is you take a step back, you look at the situation as a third party, and you ask yourself whether a reasonable person would see that as a legally binding offer. Instead, a subjective test is when the offeror, so the person who made the offer, their information and their feelings and thoughts are taken into consideration when determining whether that offer was made with the intention of being legally bound. Since it is an objective test, a lot of the times we'll look at the offer from the perspective of the offeree. So this is the person who received the offer. And we will ask ourselves whether a reasonable offeree would recognize this offer as one that is capable and has the intention of being legally binding. Before we move on to discussing advertisements and whether they are recognized as legally binding offers, make sure to subscribe to my channel to continue to receive to the point, pragmatic and practical legal information. Also, if you're interested in a free legal advice call, make sure to reach out and my contact details below. So are advertisements typically recognized as offers? The short answer is no. Advertisements typically are recognized as invitations to treat. The difference between an invitation to treat and an offer is that the offer, as we mentioned, has the intention of being legally bound, whilst the invitation to treat is when you advertise something and you ask others to come to you so that you can discuss business. The difference there is that you're not creating automatically a legally binding contract. Interestingly, when you go to a supermarket, a lot of the times it is you who's making the offer to the supermarket. The prices that you see on the products displayed on the shelves of supermarkets typically are recognized as invitations to treat. The moment you pick up that product and you go to the checkout machine and you scan that product, you're offering to buy that product at that price from the supermarket. And the supermarket accepts by taking your money. An offer to become a legally binding contract needs to be properly accepted. What is the legal definition of acceptance? When is acceptance actually recognized as a counter offer and is silence recognized as acceptance? So what is acceptance? The law doesn't actually define the exact words that must be used to recognize an acceptance as a legally binding acceptance. Instead, we look at the reasonableness test. And that is whereby, so does a reasonable person believe that that person who received the offer has accepted the offer? That is the reasonableness test. In this case, that means that acceptance must be analyzed on a case-by-case basis. One thing is certain though, that if you believe to be accepting an offer, but instead you're varying the terms of the offer that was made to you, instead of accepting, instead you are countering offering against that offer. Offers can be accepted by conduct. So for example, if someone makes you an offer and you don't say anything, but you start acting as if you had accepted the offer by, for example, starting to fulfill some of your obligations under the contract, then you might be recognized as someone who has accepted the offer in a legal way. Thumbs up emojis or any emoji that could be recognized as an acceptance do qualify and are recognized as acceptance of offers. Silence typically is not recognized as acceptance unless, for example, the two parties have a history of accepting offers by silence. Another cool thing to know about acceptance is that if you accept an offer by sending a letter via the post, the moment that you post that acceptance is the moment that you accepted the offer. That is regardless of whether that post actually makes it to the offeror, so the person who made you that offer. That is known as the postal rule. Acceptance, as we discussed, can be by conduct and even by silence in certain circumstances. So it does mean that it does not need to be in writing. Contracts overall don't need to be in writing typically. For For example, you have verbal contracts between parties all the time. We discuss the offer and the acceptance, and you believe that maybe that is sufficient to create a legally binding contract, but you'd be wrong. We actually need real consideration to be offered as part of the deal. What is the legal definition of consideration, and what are the four main elements of a legally binding consideration? Put simply, consideration is something of value. Consideration is something that is given by one party to the other in exchange for something else. So, for example, I might give you products or services, and you give me money. My products and services are the consideration for your money. Great, so what are the four main elements of a legally binding consideration? The first is benefit and detriment. The benefit must go to you. For example, if I'm the one who's delivering the service to you, there must be a detriment to me. For example, it takes me a lot of time. Second, there must be mutual promises. So, for example, I deliver a service to you, and in return, you give me money. Third, there must be sufficiency, and that is the test whereby under the law, would that consideration, that offer for services, be recognized as something of value? So simply the test is this something of value? And fourth, and related, is this something of economic value? And typically economic value is evidenced by the fact that someone has actually paid money in return for that consideration, for example, for that service. So what are the two main types of consideration? First, it's executory, so that means the person that is providing the consideration will do so in the future. So for example, if you pay me today, in the future, say within 7 days, I will deliver a contract to you. The second is executed. So for example, if you buy a product at the supermarket, it immediately becomes yours. But for there to be a legally binding contract, there must also be intention. The parties must intend for there to be a legally binding contract. And that means that even if you have an offer, acceptance, and consideration, if you don't have the intention of being legally bound, then there is no legally binding contract. What is the legal definition of intention, and when is intention just recognized as a puff, as a joke? The contract law element of intention, also known as intention to create legal relations, is going to be determined by a court on a case-by-case basis. It is a question of fact, and it is decided by reference to the particular facts of a case. So that means that a judge or a court will consider all the facts of the case and then decide whether the intention to create legal relations was present or not. Although when it comes to commercial transactions, so that's between businesses, then the intention to create legal relations is presumed. So the starting point is that there is indeed the intention to create a legal contract. If instead you're looking to rely on the existence of a valid contract whereby the acceptance happened by conduct, which is when a party doesn't expressly state that they agree or they accept the offer, but instead act as if they had accepted the offer, then the intention to create legal relations needs to be proven by you. Intention is an objective test. So it is not subjective, meaning we don't actually look at the person who accepted, for example, a contract and try to determine whether in their thoughts and feelings they actually meant to create legal relations. Instead, it is an objective test and we look at the facts and circumstances of the case. One of the things that we need to consider is whether the acceptance or offer had the intention, or was it just a puff or a joke. When we refer to puff, it's the opposite of something that it has the intention of being legally binding. So for example, a marketing puff is when Red Bull says that if you drink their drink, then you will get wings. That isn't a legally binding promise that Red Bull is making to you. Instead, it's just a marketing puff. So when does something have the intention of being legally binding, or instead, when is it just a puff? Well, it is just a puff if to the other party it should have been obvious that it was indeed just a puff. As a top tip, now that we know a little bit more about intention, when drafting your contracts, make sure to not make them too vague. The reason being is that if you make them too vague, then it is likely impossible that that contract is going to be recognized as legally invalid because of a lack of intention. So for example, if an ex-husband tells his ex-wife that she can stay at his house because the ex-wife's mother has died, the law typically would not recognize that as an offer that has the legal intention to be legally binding. This will not be legally binding because it is unclear for how long the ex-wife can stay and under what terms can she stay. So domestic contracts. Typically, the court would not recognize domestic contracts as legally binding because it is missing the intention of having legal consequences. So, for example, if you and your partner decide that you will cook and your partner will clean the dishes, it is not going to be recognized as a legal contract typically because it is unlikely that if your partner doesn't clean the dishes, you intended and you both intended for you to be able to sue and claim against your partner. But this doesn't mean that you cannot have legally binding contracts between partners. So for example, when it comes to prenups, so long as it's professionally drafted, all of the elements of a legally binding contract are present and the two partners each received independent legal advice, then that contract has a very good chance of being recognized as a legally binding contract. So until now we've discussed the offer, acceptance, consideration and intention of being legally binding. But we also need to discuss certainty, the last element of a legally binding contract. What is the legal definition of certainty, and is doing business on the usual terms going to be recognized as sufficiently certain? A court will not enforce a contract to which no definite meaning can be given. So what does that mean? Well, if the terms of a contract are not sufficiently certain, if it's not exactly clear what the parties are actually agreeing to, then the element of certainty is not there, and therefore a court will not enforce a contract whose terms are unknown. So for example, if two parties decide to enter into a contract orally, so just speaking, and they say that it will be a hire purchase agreement, a court is going to be unlikely to enforce that oral agreement because there are too many kinds of hire purchase contracts to be sufficiently certain of what kind the parties intended to enforce. But what if the parties orally state to themselves, will enter into this contract on the usual terms? Is that going to be sufficiently certain? Well, it is a question of whether the previous usual terms are in itself sufficiently certain. If they are, then a court might be able to imply those terms into the existing agreement, therefore making the arrangement sufficiently certain. What about if we have a written agreement whereby the majority of the terms are indeed sufficiently certain, but there are certain clauses in there that are not? Well, a court might decide to ignore, also known as sever, that specific clause that is insufficiently certain. The answer to whether all of the terms of a contract need to be written into that contract for certainty to be there is no, you don't need to do that. But there are conditions. So for example, you need to be able to find that information very easily, for example on a website, to be able to rely on that being part of the contract to then create sufficiency. So we've discussed all 5 main elements of a legally binding contract, but assuming that there are all of the elements present in an existing arrangement, there is still the chance that that contract is not going to be recognized as legally enforceable. What is duress and which clauses are recognized as unfair contract terms and therefore not legally valid? So under which circumstances is a contract not enforceable? Well, we'll discuss 3 main things, starting with duress. Duress is when one party places such pressure on another party that that other party feels like they have no option but to agree to that contract. So for example, when the godfather makes you an offer that you cannot refuse, that contract is likely going to be recognized as legally invalid and therefore not enforceable because you had no option but to agree. Let's move on to the red hand rule. Now the red hand rule states that if there are certain terms in a contract, especially when it comes to consumer contracts, that are so burdensome, so unfair and one-sided, those terms need to be highlighted by being written in red, and there should be a huge red hand pointing to that unfair term. This is a way to combat the fact that the majority of people simply sign a contract without actually reading and understanding that contract. And if there's a huge red hand pointing to a specific clause, then likely, or more likely, that person is actually going to read that specific clause. On the subject of unfair contract terms, let's talk about the Unfair Contract Terms Act. Under the Unfair Contract Terms Act, a clause is going to be recognized as legally invalid and therefore unenforceable if that clause causes such a significant imbalance in the rights and obligations of the parties to the detriment of the consumer. Put in simple words, that kind of means that if a clause is significantly unfair or unbalanced, then that clause is not legally valid. So when it comes to selling property or selling land, that contract needs to be in writing to be legally binding. And certain documents, such as the TR1 form that is submitted to the land registry, needs to be witnessed.